Hello. My name is Issa. I appear with my land friends, Mrs. Ahomo, Mr. Samuel Batai, Mr. Chege, and Ms. Wanjo Njoki for the Judicial Service Commission. My lords, the starting point, before I even get to the Constitution, is that none of the honorable judges of the Supreme Court have responded to the request by the Judicial Service Commission to respond to the petitions that are before the Judicial Service Commission. That is the starting point. They were invited. These petitions were received. The Judicial Service Commission considered them and then asked all the honorable judges of the Supreme Court to respond to these petitions that are before so that a preliminary inquiry could be made by the Commission. Why is that important? My lord, these are not the first petitions to be considered by the Judicial Service Commission. Very early in the stages of the new constitution, my lord, there were a number of petitions, and my lord, they are part of our bundle, that were presented before the new, let me call it the new Judicial Service Commission. And my lord, two decisions come into play. The first decision is in the case of the first Deputy Chief Justice, in the case of Nancy Baraza Makoha versus the Judicial Service Commission, and the case of the former Judge Justice Mbalu Mutava, regarding what is the role of the Judicial Service Commission. Those two decisions set the ground for the processes right now before the Commission. At the time, the Judicial Service Commission interpreted its mandate under Article 168, and the history is important, that it was a constitutional plenary power that only required them to inquire without asking the judges to respond, that there was no role for the judges. And why was this? Because the wording of Article 168 says that in the removal of the judge, under Article 168, the Judicial Service shall consider the petition, and if it is satisfied that the petition discloses the ground for removal under Clause 1, send the petition to the President. My friends keep talking about the conveyor belt. That phrase was used in the case of Lady Justice Nancy Baraza Makoha and Justice Mbalu Mutava to clarify, because we took the position, I had the privilege of being in those two cases, and I argued with Senior Counsel Ahmednassir on behalf of the Judicial Service Commission. At the time, in 2012, 2013, 2014, the position taken by the Commission was that ours is a plenary power. We simply have to look at the petition. If we are satisfied, we forward it to the President. If we are not, then we dismiss it. The High Court and the Court of Appeal clarified that no, that's not your role. There is a duty under Article 47 for you to notify the judge that a petition has been filed and whether they need, and to give them a right to respond, but with a caveat that you do not make inquiries on those facts, but you only make a preliminary inquiry. So this is the position now set out by the Court of Appeal in a 5-judge bench that I appeared before them, and that's the case of Mbalu Mutava. When you retire, I invite you to look at the majority decision that was penned by Justice Gethinji, now retired, and the concurring decision of Justice Oko on what the role of the Judicial Service Commission is. We took the position that Article 47 had no role. The judges told us, no, you're incorrect. You must inform the judges, and the judges have a right to respond. Now that is the process that is being followed here, which has been sanctioned by the High Court and the Court of Appeal. That's the starting point. Two, my lord, Malayan seniors have conflated two positions. The removal process is governed by Article 168. 172 has no role whatsoever in the removal of judges. And the investigative power, now when you retire and look at 172, 172 speaks to a different power because it says, these are the functions of the Judicial Service Commission. Under Article 172(1), subsection C, it says, appoint, receive complaints against, and then there's a comma, investigate, and remove from office or otherwise discipline. Now that power says who that power speaks to. Registrars, magistrates, other judicial officers, and other staff of the judiciary in the manner prescribed by an act of parliament. So Article 172(1)(c) that requires investigation a review, and an evaluation.
Can you mute?
Is in respect of registrars, magistrates, and other staff of the judiciary, but not judges. And the reason for that is because the removal of judges is exclusively governed by 168. And when you look at, that comes before, 168 comes before the part 4 on the judiciary, where Judicial Service Commission is established. Why is this? Because this power under Article 168 is a power that deals exclusively with the judiciary, as in terms of the courts and the establishment powers. Because when you look at the part, this is under part 2 on the superior courts. So part 2 starts from Article 163 and goes all the way, my lords, to Article 168. It ends with 168 on part 3 on the superior courts. So this is where the Judicial Service Commission comes in. And why is that is important? Because that is a standalone article that deals with the removal from office. But while I'm at it, then it starts with 1, and when you retire, you'll see that it creates, 1 talks about the grounds for removal. But when you look at grounds, the grounds, you'll read them, but the last 2 is incompetence or gross misconduct or misbehavior. So these are the broad grounds for removal of judges. Lord, let me, as I deal with the Constitution, let me talk about Article 160, so Article 5. Lord, the independence of judges, and even the finality, so I can answer the issue. If you look at Article 168, it does not distinguish between a judge sworn in this year, or as a judge of the High Court, a judge of the Environmental Land Court, or a judge of the Employment and Labor Relations Court, and the Court of Appeal or Supreme Court. Article 168 speaks to all judges, whether they sit as a bench or as single judges. So this mandate to remove judges and to consider complaints against judges applies to all judges in the same, without any discrimination. So it's the same standard that applies to the Chief Justice that applies to the youngest judge in the bench. Youngest meaning the last one to be sworn by the President at the last swearing in, because there's that pecking order. There's no distinction. What the petitioner is asking you to do is to draw a distinction that the Constitution does not create, that judges of the Supreme Court have to be treated differently because their decisions are final. Where does that apply in the Constitution? It doesn't. Yes, their decisions are final, but are their decisions insulated from the constitutional test of misconduct? No, it's not. Are judges of the Supreme Court insulated from the test for removal on incompetence? No, they're not. Because if the Constitution wanted to create a distinction, it would have said so expressly. It does not. So if there's incompetence in the Supreme Court, a judge of the Supreme Court is liable to be removed. If there's misconduct or misbehavior, and it actually uses those two words interchangeably, if a bench of the Supreme Court, and we're told they sit as 5 judges, make a decision of which a citizen feels there was misconduct in the way a decision was rendered by the Supreme Court, the only recourse they have, yes, you cannot appeal that decision, but the Constitution says you have a remedy. If there's misconduct, there is no immunity for impunity under the Constitution. Those citizens, those litigants, have a right to move the Judicial Service Commission, and how do they do that? They invoke Article 168 and say, I am dissatisfied by the way this matter was handled. I believe there was misconduct in the manner in which the Supreme Court as the apex court conducted itself, and I'm asking you as a commission to investigate and find if the Constitution has been violated. That is the test of Article 168. And what that means, my lords, is that when that complaint comes to the Judicial Service Commission, these judges have a presumption that they have done their work properly. And it only behoves the Judicial Service Commission to consider those petitions and then see if it's something about misconduct or any of those conditions. And this is not a petition like to the High Court, no. It's just a complaint to the Judicial Service Commission. I had my learned friend and good friend, Mr. Kipkoge, say you have to give particulars. No, that's not what the Constitution says. It says that complaint has to be in writing. The word petition in Article 168 means it is a complaint about a judge in accordance with the provisions of Article 168, because the Judicial Service Commission has to interpret its mandate broadly. If a man or woman who doesn't know what the word petition means writes to the Judicial Service Commission complaining about any judge, can we dismiss or reject that petition on the simple reason the word petition doesn't appear? The word particulars don't appear? No, that's not the mandate of the Commission. It has to look at its mandate broadly, and that's what it does. Third, Lords, when that comes, a decision cannot be made before the judge now writes back and says, one, this one is attacking a final decision, or this is a disgruntled. When that response comes, then the Commission then kicks in and it makes a preliminary inquiry. The Court of Appeal has said you cannot make findings of fact. That is not for you. That is for the tribunal. That brings me now to the issue of regulations, so that I can finish with this. The Constitution, where it requires any institution to make rules or regulations, it says so expressly. Now, what we're being faulted for is that we have not made regulations to exercise a plenary power that is donated expressly by the Constitution.
Just a moment, Counsel Issa. Which court directed that the JSC formulate the regulations, gazette them within 90 days?
Actually, it's coming to that. I argued that matter in the Supreme Court. This is the Gladys Boschole case. And that's why, my Lord, I started with 172 and 168 are two different articles. But this was in the case of Gladys Boschole versus Judicial Service Commission.
So are you inviting this court, as the High Court,
yes,
to inquire into whether the Supreme Court ought to have issued that directive, the 90-day directive?
The Supreme Court has already clarified that in the Site Jitembo case. That same complaint was raised by your brother, now removed judge, Justice Jitembo, that the JSC had ignored the Gladys Boschole case. And the Supreme Court quite correctly corrected the judge, because he had now appealed from the decision of the tribunal, and they said, no, those are two different things. Our decision in Gladys Boschole to the Judicial Service Commission was in its disciplinary mandate for registrars and the other judiciary staff, not Article 168 regulations. And that, my Lord, we put in our submissions. So that under the decision in Gladys Boschole, which came in at the end of that decision, what the Supreme Court said at that point is that although you have the third regulation of the Judicial Service Act, the process is not clear in terms of the disciplinary processes and how the registrars, including the Chief Registrar of the Judiciary, should respond and how the proceedings should be conducted before the Commission. And they said, from 90 days from this, our decision, please publish clearer regulations on how that mandate is to be exercised. Justice Jitembo raised this issue before the Supreme Court, and the Supreme Court in its judgment said no. Those regulations we talked about are not Article 168, they have no place and no role in Article 168. Those are for the other disciplinary process and Article 172. So there's a constitutional distinction between those two processes, and they said even absent those regulations, it doesn't affect their mandate. So that has already been clarified by the Supreme Court.
Mr. Issa.
Yes, Lord.
I heard you talk about JSC inquiring into positions to find whether there is incompetence of the Supreme Court or any other judge. So are you saying
yes,
that a litigant will just pick a decision from the Supreme Court or the decision from this court and take it to JSC for JSC to determine that there was misconduct based on the decision itself?
Lord, the complaint has to be in writing. And when this complaint comes, misconduct will come, depending on what the misconduct is. Now, the Judicial Service Commission, and this is actually what happens, they will notify the judge there's an alleged misconduct against you in how you handle this matter. Would you kindly respond? When they respond,
you handle the matter.
Yes.
I think the matter is
different. Yes.
Misconduct. I'm talking about
a decision.
You talked about a decision.
A decision.
You're saying that JSC should or has the competence to inquire into the decision and find that there was incompetence.
No, my Lord, that's not what I said. What I said is after the decision has been made, if a complaint comes to it that there was misconduct, if there was misconduct or misbehavior in how a decision was arrived at, whether that's corruption or undue influence I'm saying in the way the decision was arrived, not the decision itself, in the process.
You are correct.
Thank you, my lord. If that's I know my time is limited. So, my lord, I was answering Justice Mamuye. My lord, so and my lord, if I can finish with that point, then I can go because I know I have 20 minutes. My lord, I was saying where the Constitution requires regulations or even other further statute, it says so expressly. And my lord, you don't need to go very far. There are two I can give you. Article 23 requires. I can give you two. Article 23. My lord, 22 on enforcement of Bill of Rights. My lord, if you look at the Constitution, it says, at Article 22, sub-Article 3, my lord, so you deal with this, you are aware of this, the Chief Justice shall make rules providing for the court proceedings referred to in this article, which shall satisfy the following criteria. Then they say, and then at 4 it says, the absence of rules contemplated in Clause 3 does not limit the right of any person to commence court proceedings under this article and to have the matter heard and determined by a court. The same thing, my lord, is given to the Supreme Court, where the Constitution requires those rules to be done. When you look at Article 163, sub-Article 9, it says, Article 163.8 of the powers of the Supreme Court, under Part 2, the same part we are in, it said the Supreme Court shall make rules for the exercise of its jurisdiction. And then 9, and I want to make this distinction, an Act of Parliament may make further provision for the operation of the Supreme Court. My lord, when it comes to 168, what was the constitutional intent and design? What you find is that there was only one organ between the Judicial Service Commission and the tribunal that the Constitution was clear about, and that's the tribunal. Because when you look at 168, at sub-Article 10, it says, Parliament shall enact legislation providing for the procedure of a tribunal appointed under this article. It didn't say about it didn't talk about the JSC, the proceedings before the JSC. It was very clear. It says Parliament shall enact legislation providing for the procedure of a tribunal appointed under this article. And my lord, that institutional design, you find it in the Judicial Service Act. Because when the Judicial Service Act was passed, and I come now to the issue about the issue about publication, when you look at Section 31 and Section 32, they talk about the tribunal. And the tribunal's proceedings are governed by the schedule to the Act, which is not subsidiary legislation. Sometimes people call it subsidiary, but this is just part of the Act. And Schedule 3 deals with the tribunal. When you look at second schedule, which starts immediately after the first schedule, it deals with provisions relating to the procedure of the tribunal on removal of judges. But there is no procedure on what this JSC should be because the Constitution didn't require that, and the Judicial Service Act, in conformity with the Constitution, did not require for that, for any regulations. And now, let me come to Section 47. Section 47, on the other hand, says this, my lords, and that's why I think when we read these sections, it's important for us to interpret them properly. Section 47, the one that all the judges have referred to, talks about regulations. And this is what it says. The Commission may make regulations for the better carrying out of the purposes of this Act. And under 2, it says, without prejudice to the generality of subsection 1, such regulations may provide for, and this is the one that is important. Let me just define it. There's one, the one for the administration, there's one, actually when I look at these regulations, the one about, C, preliminary procedures for making any recommendations required to be made under the Constitution. But why is that important? But there are 2 recommendations that the Judicial Service makes. Recommendations to the President for appointment of judges, and recommendations to the President for setting up of a tribunal. My lord, the argument being made by the judges of the Supreme Court is that the Judicial Service Commission cannot exercise its plenary power to nominate judges for any of this High Court, either High Court, Court of Appeals, or Supreme Court, because there are no regulations on how that nomination should be done. Because it's the same power that deals with the nomination for appointment of a tribunal. If that argument were to be made today that all the judges that have been appointed since the promulgation of the Constitution are invalid because there are no regulations on how they make the recommendation, it will be flatly rejected by the High Court. Because that regulation cannot take away from the power of the Judicial Service Commission to appoint judges, to recommend judges for appointment, and similarly, it cannot take away power to the commissioners to consider recommendation to the president for the removal of a judge where the constitutional threshold has been met. So those regulations cannot really, under Section 47, Section 47 cannot limit the power under Article 168 or the power to recommend judges for appointment, because it's the same power under 47 2C. They're all constitutional recommendations. So
Article 168.
yes,
When we are doing those preliminaries, are there guidelines?
guidelines.
Yes. In form of rules or regulations, or it's just done by rules of the
No, it's not.
JSC?
And that's what I was, and we've explained. When you read our reply affidavit, we have said now, we have done over 992 complaints, or they have dealt. When I say we, I'm not a member, but my client has dealt with over 992 from inception of this new Judicial Service Commission. And only out of those, only 12, less than 1%, have gone beyond the threshold. And they have explained that what they do, they look at a subcommittee set up, and then the commissioners, that subcommittee then advises the full the commission, then the commission makes a plenary decision. Should we ask the judge to respond to this? And when the judge responds, then they consider that response, and then they make that preliminary inquiry. Most of the petitions to the Judicial Service Commission fail at that stage, but a few go a bit further, where some facts have to be clarified, or the rival contentions have to be clarified, and both parties are called. It is not a hearing; it's an inquiry. The commission then asks the complainant, "You said this about the judge. The judge is here; he's hearing. Clarify that." The person clarifies that. The judge asks, "Can you clarify that position?" And then they make a determination. That's only in exceptional cases, but they do have a preliminary inquiry. That has been the process, and that is the process that is still being deployed.
So they anchored in Article 47 of the Constitution,
Yes.
or the general rules of.
No, Article 47.
No,
It's Article 47.
No.
But the Article 47, my lord, has been clarified by the Court of Appeal in the Mutava decision, because we had taken the position it doesn't apply. The Court of Appeal told us that Article 47, remember, yours is circumscribed under you need to read Article 47 together with Article 168. You make a preliminary inquiry without making a final determination of the facts. It is just a threshold inquiry. If you are satisfied that the constitutional threshold under Article 168(1) has been set, then you forward it to the president, who now sets up a tribunal which inquires into the facts. So that is actually the test that the Court of Appeal has sanctioned and said that is a process, and that is what has been deployed throughout. So we are not a conveyor belt. We never convey any complaint to the president without making that preliminary inquiry. And that applies to the Supreme Court judges, Court of Appeal judges, and other Supreme Court judges. I know I'm 20 minutes or so.
No, your time was not running.
Oh, sorry, we already have answered a few questions. Can I just then clarify 4 points and I sit down? My lord,
So let me put your time back on.
yeah. So, my lord, one, the issue about the judicial, that Senior Counsel James Ochengodol raised in submissions and has been highlighted by Mr. Omar, was raised in the matter for Baru Mutaba. And we clarified then that in South Africa, although we borrowed from them, the process is different. In South Africa, the Judicial Service Commission does the work of the tribunal. So that distinction has to be made, and it's there in the judgment. That when you look at the Judicial Service Act in South Africa, they actually make the inquiry and then they report to Parliament. My lords, when you return and look at the final committee, the Committee of Experts report, that is the structure we had before the harmonized draft.
Okay, Mr. Issa,
Yes, my lord.
there's something I want you to clarify.
Yes, my lord. That's
About
supposed to
this
talk.
issue about the issue of preliminary inquiry.
Yes, my lord.
Assuming a judge, somebody files a complaint or a petition to the JSC,
Yes, my lord.
seeking the removal of a judge,
Yes.
because the judge has claimed that they have gone to heaven and come back,
Yes.
would the JSC require the judge to respond to that allegation?
That they have gone to heaven and back. The judge or the litigant?
The judge. Assuming
Yes.
somebody sits
Yes.
down,
Yes.
right, a petition to the JSC.
Yes.
It says that they are seeking the removal of a particular judge
Yes.
because this judge claims that he has been to heaven and back, and forwards that complaint to the JSC.
Yes.
So would the JSC still insist that the judge must respond to that complaint?
Yes, my lord, because the judge may not have said that. He might have spoken in Latin. So,
Okay. So,
yes, the judge has to respond because
so it doesn't matter the nature of the complaint. That is what you are telling us. Whatever JSC receives, the judge must
No.
respond.
no, and that's why there's a first preliminary inquiry. They sit as a small committee.
So what is this preliminary inquiry?
The
Because
preliminary
first
inquiry-
preliminary inquiry,
Yes.
you say it's because judges have not responded.
No,
So
so
at
the
that
first
particular
one-
point, was
yes.
a preliminary inquiry conducted?
Yeah. So the complaints are many, and what they do, they look at if this complaint is just saying I'm unhappy because the judge ruled against me, and there are some that are actually dismissed at that stage, and the commission says this is not about. There's no allegation of any misconduct against this honourable judge. There's no any allegation of misbehaviour. This is a disgruntled litigant, is an unhappy litigant, and there's no allegation in this long letter of any complaint or any misconduct on the part of the judge. So they normally write back and say, this matter, because it's a court of first instance, look, you're unhappy with the judgment, please exercise your right of appeal. This is not a matter that is for us.
So in essence, you are saying, before the commission writes to the judge or
Yes.
requires the judge to respond, they must satisfy themselves as to the prima facie threshold of that particular complaint.
My lord, the first one, the preliminary, let me clarify. The first one is whether this one, now they have to go with the Mutava Musimi requirements of the Court of Appeal that ask the judge to respond, because sometimes there is an allegation there against the judge. And so that preliminary inquiry is, the first one, my lord, is not even prima facie, is there anything that the judge needs to respond to and clarify? So if they say there's something the judge to clarify, they write to the judge and say, this complaint has come to us, please respond to these allegations. And then the judge responds and then they deal with it. And most of the time, they end up there, they consider it, they see it, and they say it does
And
not
that
meet
is
the
why
definition.
I think
Yes.
we are concerned. Is this something that is in the rules or in the practice?
No, so,
What they're supposed to do?
My
Is
lord-
it in the rules or practice?
and that's why, my lord, what the court has clarified, because we said it is not meant to, the JSC is not meant to discipline judges. Let me start from there. My lord, this has to go on record that JSC does not discipline judges. Its work is to receive and to process complaints. Yeah, so because there's that, the issue about the disciplinary process is for the tribunal and an appeal to the Supreme Court, and I'll come to the last point about one of the allegations that said that they cannot be subjected to that because there'll be no Supreme Court to respond to. I'll answer that as my last question. So, my lord, so the work is to consider, does it meet the constitutional threshold? If it does, then they write to them and then they come back. If it doesn't, yeah, so my lord, if it
Are there
doesn't,
people there who are sharing with us?
Come again?
People who are already? Yes, already.
so,
Okay.
so my lord, as a commission, then it has wide powers under Article 249, 250 to consider all these things. And what they have now, my lord, is 12, 13, 14, 15 years of experience of how to process them. And they process them, and they have done that with fidelity to the Constitution. So they have done that fairly and very, they do not dismiss any complaint that comes to them. It has to be processed. And once it's processed, because that's in fairness to the complainants or the petitioners, they now do that first. They first look at it. Does it raise any complaint on any of the 5 grounds? If it does, we write to the judge, ask him to respond, and then they say, does it meet now? The second stage, and Justice, to answer Justice Mugambi, it's where they now deal with the constitutional threshold. Does it meet the constitutional threshold for us to forward it to the president? And most of those petitions or complaints fall at that stage. They do not meet that stage, and what happens next is that the commission writes to the petitioner and to the judge. They say, we have dealt with this matter, we do not find it meets the threshold, and the file is closed. So that's what happens.
So the process that you have explained
Yes,
is
Lord.
what I wanted you to confirm.
Yes.
Is it contained in the rules or the practice of the commission?
It is in the practice and their own, and in fact, as the Act of the Constitution requires them to do, they are meant to come up with their own internal process.
Assuming that they want to wake up today and decide not to follow that process, what happens?
But
The process in practice.
if they were to not to follow that process,
Yes.
and
Assume because it's not anywhere, it's not recorded, it's not documented anywhere. That is
Yes.
what they do as a matter of practice.
And that's
Assuming
what-
that
yes.
for a particular judge they follow the procedure. For another judge, they just wake up and write back to the judge and tell him, respond. Even without going through that preliminary process, how will we know that the committee is operating in the same way in respect to all the complaints that are taken to the commission?
Because, my lord, and this is where we have to be, because the commission is not meant to do a first stage
I
hearing.
understand,
Yes,
but
my
you
lord.
have explained, and the reason why you explain it because you are saying that the commission adopts a fair process, an objective process
Yes.
in processing those complaints. But what I am trying to find out is if today
Yes.
they adopt that fair process in respect to a particular judge, tomorrow
Judge.
they
They don't.
decide to omit or not to do it.
Not to go through
How
it.
will we know it? How will we be able to establish that the same practice they have used against Judge A is the same practice they have used against Judge C?
And my lord, and the only time that will come into play, my lord, is if there is a recommendation to the president. Yeah.
Just a
Because-
moment, Councillor Issa.
Yes.
Let's zoom out a little bit.
Yes.
Does at the JSC stage,
Yes.
is there a point at which the JSC calls witnesses? So the complainant presents a case, the judge presents their side.
Yes, it does. It does, and they're not really witnesses because what it tries to do is clarify, because there's no hearing, but it does ask people to clarify the facts. For example, there are some complaints that come and say the judge did this and this in court. What the court says, it asks the judge to respond, and then they can ask either the court clerk, or for example, they say the judgment wasn't delivered. There are very many complaints that come, different ones.
So
What it does, it makes an inquiry.
You've brought up the
Yes.
Rawal decision.
Yes.
The Court of Appeal appeared to be suggesting that none of that should happen at the JSC stage at all. That what the JSC should do is a preliminary inquiry, see if there's something there, any fact finding,
And
anything from the court clerk in the example you've given, all that is for the tribunal.
actually, even Mutaba said the same thing. What it said is you must make a preliminary inquiry. Don't go into the facts, but you must find out if you meet the constitutional threshold. It's a very fine judgment, Judge, and you're right. And so, to balance that, because of some of the serious allegations that are made, they do make that inquiry. Now, my lord, in terms of how far they go in that inquiry, it depends on the nature of the complaint. And because the issue at the back of the mind of the Judicial Service Commission and commissioners is that they cannot be a conveyor belt, and because of the implications of making a recommendation to the president. Yes, my lord, they cannot make a fact finding. They are not allowed to go into the facts. But my lord, if an allegation has very many gray areas, they just say, let's just shine some light on this without going into the facts.
So what goes to the president is a detailed report from JSC,
It is-
including proceedings, including
Look,
findings.
they do a report, my lord. And
Yes.
if you look at what they do a report to the president, say a complaint came to us, we've looked at it, we're satisfied the threshold has been met, and we recommend the appointment of a tribunal.
I've had the privilege of being a member of
Yes.
5 of those
I
tribunals.
was about to mention that, my lord. I wasn't sure whether that was the complaint we're being told we shouldn't mention some things about judges, but I'll come to that.
And I believe you were there for the first one, the Supreme Court judge. I don't want to.
Everyone is.
Yes, I don't want to mention the name.
Yes, my lord.
There was certainly a detailed report, including we've gone to the site, we've seen the road that has been built to the judge's
Yes.
house, but in others there is no such detailed. So as my brother Mugambi J is inquiring, how do we tell? In some instances there are detailed
Now-
reports, in others there are none.
If this is now I come to now that because of the body of work that we have now kicked into some, regulation 47. We've said because we are, now people are more aware of these infractions and complaints and the many. We have come up with regulations just on how to process map of complaints before the JSC. So those are a comprehensive guide that I can call them guidelines and regulations that have now been done. They've gone through stakeholder. If you look at our replying affidavits and all the petitions, we've said because of the number of complaints and and the protracted nature of judges being, and our work is to protect judges, not in a bad way. The independence of the judiciary is at the heart of the mandate of the Judicial Service Commission. So there are now regulations, to answer Justice Mugambi and his concern, that have now gone through the stakeholder engagement, and they are just about to get approval from Parliament for them to be gazetted as a process, just on the issue of complaints, so that people know what time it will take, because sometimes it takes very long for the complaints to be processed. And so it will show how that will be done, the period within which a judge has to respond, and when to expect an answer if you're a complainant. So it's a bit detailed, but it's there.
Okay.
So those regulations, my lord, in terms of going forward, we already have the regulations now. But the constitutional question is that, can we act without those regulations? Yes, my lord, we've done it, and our success rate is 98%. 98% of those complaints have been dismissed because of that rigorous process we go through.
Your time is back on.
Yeah, thank you, my lord. So that's 3 questions, my lord, I can answer. One, because I think I've answered all the constitutional issues. My lord, I just wanted to address 3 issues and I sit down. My lord, those regulations, even when they come into effect, they will not affect Article 160, so I leave that. That will make lengthy submissions. 2, my lord, I have clarified about the position. My lord, Article 10 is a normative, and all of you have had to deal with it, on transparency and accountability. When the Judicial Service Commission, and it does this periodically, notifies the public on all the complaints it has received and is processing, it's all about being accountable. Because as my Lord Justice Mugambi has said, some complainants don't know whether it has been swept under the carpet, so they come and say, we have received, even against our own leader, the Chief Justice, who is the head of the Judicial Service Commission, we received a complaint and we're processing it. So that disclosure, my Lord, is an exercise, we're just bowing down to the Constitution. We're being transparent, we're being accountable. And we're saying it's still in the process, and it has been processed. Can we be faulted for being accountable? For being transparent? You know, the accusation against all other institutions of government is that they're opaque. We are being accused of being too transparent. That cannot be a basis for you to grant any orders today. The third question, my Lord, and I heard what Mr. Said, that can wait until the determination. But when you're making a report on all these complaints, you just have to be clear. These ones we processed, these ones we are still in the process of determining them. The fact that a complaint has been made doesn't cast any aspersions on any judge, because of the rate at which most of them are dismissed. So there's no violation of any of the rights of the Honorable Justice Ogo, who, to be fair to him, wrote a very good concurring opinion in the Balu Mutava case, my Lord. I'd invite my Lords to read it. My Lord, on the issue about the Muya advice by the Supreme Court, my Lord, we don't treat, and I think our replying affidavit shows, we don't treat them casually. My Lord, 2 interesting things about the submissions by Her Ladyship, Lady Justice Mwilu. My Lord, when you read the Mwilu decision, which is one of the decisions, when I say Mwilu decision, I say where she petitioned against the DPP and the Judicial Service Commission. A 5-judge bench of the High Court has clarified that when there are complaints that need to be made against any judge, the first port of call has to be the Judicial Service Commission. Now, my Lord, that is exactly what those interested parties did. And no other state organ can handle a matter regarding a judge. That judgment remains good law until the Judicial Service Commission has had a say. My Lord, 5 judges of this court looked at those allegations that have been made against Her Ladyship, and they said the DPP jumped the gun, all these other, the DCI jumped the gun, and I agree with them. So when we have any serious allegation, we must have an institution that the public can come to, and that institution is the Judicial Service Commission. The High Court agreed. Now, when we're doing, to reassure the public that there are no sacred cows in the judiciary, we are being faulted. But Her Ladyship, Lady Justice Mwilu, when she filed the petition to this court, her complaint was the opposite, that, look, you cannot touch me until the Judicial Service Commission has had a say on these matters. But let us have a say, let the Honorable Judges respond. We will deal with this matter fairly. We are not going to remove these judges if because that is the fear. No, we don't do witch hunts. We are very independent, and we consider all complaints very, very seriously, and we treat them very, very fairly. That is our undertaking on behalf of the Judicial Service Commission, and that will continue. And the last one, my lord, there was an issue, you see in the submission, which is an issue of law. And His Lordship Justice Mamuya would be aware of this. All the judgments that come from the tribunal, let me call them decisions, they're not judgments, they're not, the tribunals make decisions that go to the president and the appointed. Well, a very valid question was raised. If any of these judges had a determination against him, where would they go? Because the other judges are brothers and sisters in the Supreme Court. Well, the answer is in the Constitution. Well, when you retire, and I invite you to consider this, because I know it has not been litigated, but maybe you could weigh on it. When you look at Article 165, you know it has very many corners. But this corner has not been, the light has not been shown on this, and it's time that we do that. When you look at 165 3C, I know my line friend talked about 165. 3C is an important, and it was thought about in the 4 stages of our constitution making. 3C came in the final, the harmonized draft. It says, jurisdiction to hear an appeal from a decision of a tribunal appointed under this constitution to consider the removal of a person from office other than a tribunal appointed under Article 144. My Lord, why was that put there? The simple reason of the Supreme Court judges. And so they should have no fear that the Constitution took care of them. So even if the whole of the Supreme Court were found somewhere huddled together and the complaint was found valid, there's a constitutional pathway for them. And that is highly unlikely to happen because Article 165.3 says the only tribunal that the High Court cannot hear an appeal from, and all the other ones, because they cannot sit because of the bias and the doctrine of necessity, under the doctrine of necessity, the High Court has to hear that petition. Because this was raised, and validly so,
Sorry, Counsel Issa, let me just pause your time.
Yeah.
How do we marry that with the express provisions of Article 168, Clause 8?
Yes,
Says
and
expressly.
168, because you see now, that's where the necessity comes in. 168.8, because my Lord, you know there's also the other, I'll come to it. 168 says this. A judge who is aggrieved by a decision of the tribunal under this article may appeal against the decision to the Supreme Court within 10 days after the tribunal makes its recommendation. My Lord, that for all other judges is an express provision in the Constitution. If the judges of the Supreme Court, for example, find, for example, my Lord, it has to be within 10 days. If perchance, and that it could happen, I'm saying under Constitution we have to think about the worst case scenario. If, for example, there was credible evidence, I'm just saying for example, and I don't need to be quoted out of context, that the judges of the Supreme Court were under so much pressure from one arm of the government, whether Parliament or any other arm of government, that they made a decision that goes against the Constitution. A complaint is made, and the JSC recommends to the President. President sets up a tribunal. The tribunal says, yes, it's true. These judges bowed under unconstitutional pressure and made a decision that is not compatible with the Constitution. They should be removed from office because they're allowed to be removed under the Constitution. What would happen to those 5? They cannot appeal to themselves, my Lord. I'm saying, so that's the worst case scenario. Under the doctrine of necessity, my Lord, they either go home or they appeal.
In Tunoi, in the Tunoi, let's use the example of
Tunoi, yes.
the Tunoi example.
Yes, my Lord.
Renders a decision in the Court of Appeal.
Yeah.
Sits in the Supreme Court, applies the doctrine of necessity.
Yes.
Because otherwise, the Supreme Court would not have had quorum.
Yes.
What would be different here?
My Lord,
Because the individual Supreme Court judges would be saying, unless we follow the Tunoi precedent, the Supreme Court will have no.
But my Lord, this is one where all the five or six of them go. I'm just saying, in a case where the complaint is against one bench, maybe say 5, not the 7, say 5. If each individual is found to be liable and they're to go, and they're to be removed by the President, my Lord, there would be no bench to hear because there would be judges in their own cause. In those circumstances, my Lord, do they not challenge the decision? Or do they now look at this Constitution and say, is there any other way where I can go? And my Lord, that's where 165.3C comes in.
Where can they challenge it?
My Lord, that's why I say it now. That
High Court overall.
no, it's the High Court. no other place and
What
have 10 days
about-
to do that.
What about 165.5a, exclusive
Oh, no, I dealt
jurisdiction
with that in the other one where I sued the
of the exclusive
Let me just
jurisdiction of the
answer
Supreme Court?
You know, I don't have that like this. Just, you can't be so So, my lord, the shall within 14 after receiving the petition suspend the judge and acting. My lord, you're talking about the tribunal for the Chief Justice.
Yes.
You asked me to 165A.
165,
Yes, 5A.
clause 5, paragraph A.
Yeah, so it says, let me just read that, my lord. The president shall within 14 days of receiving the petition suspend the judge from office and act.
No, 165, not 168.5. 165, jurisdiction of the High Court.
Yeah, oh, sorry, 5. Oh, I was in
165.
168, sorry.
Yes, you're in 168. 165.
5. But let me go there. Let me go there.
Exclusive jurisdiction of the
Yeah, my lord. The High Court has supervised. The High Court shall not have jurisdiction with respect to matters reserved for the exclusive jurisdiction of the Supreme Court under this Constitution, or falling within the jurisdiction of the courts contemplated in Article 162(2).
Is the appellate from the tribunal to the Supreme Court an exclusive jurisdiction?
The one
of Supreme
for the judges.
Yes. Isn't it that exclusive only?
No, my lord. Now that's why you harmonize the Constitution. That's why harmony comes in here. Because you say there's exclusive jurisdiction, but then you come back to 165.3 and you say, let me take a pause. The only one that has not been excluded, the one that has only been expressly excluded is the tribunal under 144. They do not talk about the one under 160, the one about the removal of charges. And that was very fine calibration.
There was a reason at Bomas
Yes.
to harmonize the Constitution why the 144 was excluded from the High Court.
Yes.
Because it's on the President. So there's a consistent constitutional theme where
In fact,
matters for the President go.
no, there was that, my lord, you'd be surprised that, and I'm not making this up. The Chief Justice was never the head of the Judicial Service Commission, but the Parliamentary Select Committee insisted in the very final draft that we now put to the, in all the other drafts, if you look at it, and I'm a student of the Constitution, and the lecturer here can confirm this, is that they did not have the Chief Justice, for the same reason a lot we're dealing with here. They were saying, when it comes to the Chief Justice, would she be subjected to a disciplinary process by her juniors as the head of the judiciary? And they said no. For the Judicial Service Commission to have a buy-in by the judiciary and the public, we need to have the Chief Justice as the head of the commission and the head of the Judicial Service Commission. So the Chief Justice wears two hats, head of the Judicial Service Commission. That was as a result of that compromise. And then that issue about the process, how is this process meant to be? Well, the first recommendation was that this disciplinary process we're dealing with should be by the commission. There will be no tribunal. The president had no role to play. It was meant to be by the commission as a fact-finding organ, and then the recommendations go to Parliament for approval. In the final draft, after went to Naivasha, they said that will not. It will give us a problem with the public because we want an independent judiciary and we want an independent Judicial Service Commission. How do we insulate that process? My lord, that's why this two-tier process came in. I'm not making it up, my lord. When you read the final report of the Committee of Experts, it's there. So we had to haggle to come to this place. But I think just Mamui has a point that then what happens, but that's why the Supreme Court came in. Bias is in the Judicial Code of Conduct. When the late Justice Ibrahim had to sit in the Rai matters, because had he not sat, because that time the Justice, the Deputy Chief Justice had been removed, there was not going to be they didn't have a quorum. And Justice Tolui had sat in the Court of Appeal in that judgment that came up. I think my senior Justice Aura would remember this. And they said, look, we understand bias, we understand Judicial Code of Conduct, but
I think
I'm finishing.
You asked me to clarify.
Oh, yes, sure.
Yeah. And you got it a bit wrong.
Yes.
Because the issue there was disqualification of Justice Tolui.
Tolui, yes, I've said
Yes,
Tolui.
and the court decided that since it is a collegial court,
Yes.
yeah,
No,
he could say despite
Sorry.
any other reason they may have.
It was Tolui. Yes.
We didn't deal with Ibrahim.
No, I'm saying in the Ibrahim's concurring decision in Rai, Justice Ibrahim the late made it very clear because he wrote a concurring single opinion. He says that principle applies in most of the cases that will come before us, but for this one, we have to sit because absent Justice Tolui, we cannot have jurisdiction to hear this Rai case, and that's the only reason. So, my lord, for that, if that, and God forbid, it will never happen, but if it was able to come, I was just answering a constitutional question. We have an answer in the Constitution. In that circumstance, my lord, the High Court will close its eyes and say, today is the day. We have to hear this. Thank you, my lord. Unless you have any question, my lord, we rely on our submissions. I hope I've answered all your questions.
You still have 2 minutes and 17 seconds if you wish to utilize it.
You don't have a team here. Let me just ask them if there was anything that I have not answered. And yes, my lord, I think there's only one question about Justice, my Lord Justice Lanaola. I think that's a valid complaint against the Commission. You know, when we make a mistake, we raise our hand. What he says is correct. If there was no complaint against Justice Lanaola by Diary Limited, it was remiss of the Commission to ask him to respond. But that only shows that the commissioners are human. So the 98% were still there. So that, my lord, I raise my hand. I say that, yeah, that, and I think. But now, a good judge like Lanaola, who's been a commissioner, and we have the privilege of most of the judges of the Supreme Court having had been commissioners, is to correct them and say, I was not in that bench, so there's really nothing for me to explain, and the matter dies naturally there. Once he clarifies that matter naturally dies there. And so I'll argue, my lord, that why we're saying this matters are premature is that allow the Judicial Service Commission to consider these petitions, let them exercise their plenary power. They will process them very fairly, as they've always done. And, my lord, if they have no merit, my lord, they don't meet the constitutional threshold, the Commission will say they do not meet the constitutional threshold and they will dismiss them. But for those reasons, my lord, we urge you not to allow these petitions. Allow the Commission to exercise its mandate, my lord. We refer you to the, and my lord, just the last question about the case of Uganda. I remember a Senior Counsel referred to that case. No, my lord, the only reason we gave you the Uganda decisions are two. There's not one case, there are two decisions. My lord, the Judicial Service Act in Uganda is very similar to our Judicial Service Act. Their constitution predates ours by a few years, but it's very progressive. The only difference is that in Uganda, and I say this with a lot of respect to our neighbors, the judiciary and the Judicial Service Commission have really upheld their constitution. So when it comes to judicial immunity and judicial, if you look at the interpretation, they say judicial immunity is sacrosanct, but where there's a complaint about misconduct, that the Commission has a duty to investigate and to inquire. And so there's no immunity that is shielded under the Constitution under Uganda and as well as ours, where a complaint about misconduct arises. And why is that? So that Article 165, and this is my last sentence and I sit down, it's very important, my lords, as you retire, to remember that judicial immunity that is conferred, and it's global, and Article 160 is Article 5, my lord, and I said this because most people forget this, that immunity, my lord, is never for the judges. My lord, it's for the public, so that parties can be sure when they appear before you and they're up against the government, you are independent, that you'll be fearless and you'll make the right decision. And that's why the Constitution undergirds that. It ring-fences that independence so that you can do that. And that is why you have that. Your decisions are shielded by the Constitution so that the public can be reassured that they have faith in the Constitution. It has never been, and it will never be, about the judiciary or the Judicial Service Commission. And that is why you should allow this process to continue so that we can safeguard that judicial independence. Thank you, my lords, for giving me the time.